And GMA legal analyst Dan Abrams now, and Dan, a crucial day, as we've been saying. Sandusky will be facing all of his alleged victims, and we're told that this is going to be the first time that he's seeing them in court. You've been saying this is like a mini trial. What's the goal here for the prosecution?
The goal is to make sure that this case moves forward to a trial. This is basically a very low standard here in the preliminary hearing, just to make sure they can demonstrate to a court there's enough evidence to move forward. So they don't want to go overboard. They don't want to present too many witnesses. They don't want to lay out the entirety of their case. They want to present just enough to say to the judge, hey, on each and every one of the counts charged, we've got enough to go forward.
Is it true that the defense could have waived this and not had this hearing?
And most of the time they do waive it. In fact, Pennsylvania is one of the few states where it requires both a grand jury, which sort of serves as a fact finder, and then a preliminary hearing where a judge rules, okay, now there's enough to move forward. In most states, a grand jury actually does the indictment, and that allows the case to move forward. So in Pennsylvania, very often a defense attorney will waive the preliminary hearing knowing that they're going to lose. I mean,
so why not in this case? Why didn't he do it in this case?
The defense wants to cross-examine witnesses. They'd like to get the accusers on the record so that they can potentially get inconsistent statements with them later. So the fact that the defense is moving forward here and not waiving tells you that they're ready to do some real cross-examination of these witnesses.
Don't expect to see Sandusky up on the witness stand of any sort.
I mean, look, I would have told you don't expect to see Sandusky do an interview on television. So the fact that he did that would prove me wrong. I would be absolutely stunned if Sandusky took the stand. It would make no sense at all for him to take the stand at this point, put himself on the record, subject himself to cross-examination. It would just be crazy, in particular because the defense knows they're going to lose. They know they're going to lose this hearing. It's an interesting type of hearing where the defense goes into it knowing they have almost no chance, so they don't want to lay all their cards on the table.
How quickly do you think the judge will rule?
Almost immediately. So let's assume this takes 2 days. Judge could rule from the bench right there and then.
All right, Dan. Thanks very much.